right, good morning, everyone. All right, we are here.
Good morning.
We are here on Joshua Burns and Trishelle Garner, plaintiffs versus Amazon, cause number 24-2225749. Can I have the parties make their appearances for the record? Why don't we start, is it Mr. Subit? Is that how I pronounce your name?
It is. I am co-counsel for the plaintiff, but I will not be speaking today.
All right, good morning, welcome.
Good morning, Your Honor. Timothy Emery for the plaintiff. I will not be speaking today either. Be Patrick Reddy.
All right, good morning.
Yes, good morning, Your Honor. Patrick Reddy for the plaintiff in the class, and I will be arguing today.
All right, good morning.
And good morning, Your Honor. Theodore Boutros. I will be for the defendants, and I will be speaking today.
All right, good morning and welcome.
Good morning.
And good morning, Your Honor. This is Katie Chan. I'm appearing as local counsel for Amazon defendants.
All right, good morning, Ms. Chan. All right, so we are here on the parties' cross motions for summary judgment. Just to let you all know, I've reviewed all of the briefing and all of the exhibits submitted by the parties. That includes defendant Amazon's motion for summary judgment with attached exhibits, the plaintiff's opposition to that motion with attached exhibits, and defendant Amazon's reply. I've also reviewed the plaintiff's motion for summary judgment, Amazon's opposition to that motion, and the reply in support of that motion. So we've calendared this for an hour, but there are a number of issues and cross motions. So if it sounds all right to everyone, I'm thinking 20 minutes per side with perhaps 5 minutes of rebuttal. Does that work for folks?
That does, Your Honor. Thank you.
Okay. Why don't we start with defendant Amazon's motion for summary judgment? Let's start there. And you all can obviously approach your arguments however you would like. If you'd like to combine them, that's fine. For both motions.
I think I will, Your Honor.
Right.
I think they overlap.
Correct.
And
right.
I think.
Yeah.
And again, Theodore Boutros for the Amazon defendants. Plaintiffs are asking this court to impose hundreds of millions of dollars in statutory penalties for contract provisions that were lawful when they were entered. They were never enforced against the named plaintiffs or any of the class members. It's undisputed. And the contracts have harmed no one. And so I know the court's plowed through all this material. To me, the most straightforward way to resolve this case is to reject plaintiffs' misguided attempt to retroactively apply the 2024 amendments to the Washington non-compete statute, which to impose these massive penalties based on agreements that were completely lawful when they were entered under the 2019 statute and the common law, and then grant summary judgment on that basis. For nearly a century, Washington law permitted customer non-solicitation provisions like the one at issue here, and that included this sort of non-acceptance of business clause. The 2019 statute didn't change that. It preserved the framework. It expressly excluded non-solicits from the statute's prohibitions and expressly preserved the common law, which allowed this sort of non-solicit as opposed to an unreasonable non-compete provision. And then courts after that, like the Griffin-McLean case, Wellspring, Place for Mom, interpreted the 2019 statute to allow non-acceptance of business provisions like the one here. And so the agreements were lawful when they were entered. The undisputed evidence shows that they never actually restricted these named plaintiffs or any of the class members. And I think it's in the record that Amazon has changed the provision just to make it even clearer going forward. So this is a case searching for an injury and searching for a problem. And so we believe that the court has ample grounds to rule that the 2024 amendments do not retroactively apply. They clearly substantively changed the law. And the FD processing case that we've relied on from the Supreme Court of Washington, many other cases say the presumption of no retroactivity is strong in Washington. There has to be clear intent to apply a statute retroactively, especially where we have vested rights, vested contractual rights. and due process concerns. And here where they're seeking to override nearly a century of judicial precedent from the Washington courts and the 2019 statute and its provisions, and that they're seeking these penalties. No one's been hurt. No one argues they've been injured. This is punishment that they're seeking. And so there's no evidence of the kind of clear intent for retroactive application. So as I said, we believe summary judgment can be granted on that basis alone, but it's not the only basis. As the court knows, there's standing issues here. And whether we call it constitutional, jurisdictional standing in Washington or just statutory standing, no one has been injured. There's no concrete injury. And I thought the Benton County case that we cited, probably the most recent Washington Supreme Court case on standing, says there has to be concrete injury. Speculation is not enough. The courts are, this is me talking now, the courts are busy enough without having to resolve hypothetical disputes where no one's been harmed, where the provision at issue does not apply to the plaintiffs, was not intended to apply to them, never was applied to them, or any of the class members. So let me just go back to retroactivity and start with that point, because I think it's just very straightforward. As I said, since 1927, the Racine case, the Washington courts allowed non-acceptance of business and non-solicitation provisions when an employee moved from an employer that basically say you can't go after our clients and take our clients or accept business from our clients for a limited period of time to protect our confidentiality and our client base. And there was the Perry versus Moran case, fast forward to 1987, the Emmerich case and other cases that get us all the way into the 2000s that have said that. The 2019 non-compete statute expressly preserved those sorts of non-solicitation provisions. It defined the non-competes very narrowly as contracts that prohibit or restrain an employee from engaging in a lawful profession, business, or trade of any kind. And there's no dispute that the provision here did not do that to anyone at Amazon. It was not that kind of restriction. And then the statute expressly accepted non-solicitation provisions from the definition of non-competes. And we believe that was clearly with the common law in mind, because it then has an explicit provision that says the common law is preserved unless expressly stated otherwise. So we've got, as of 2019, the law allowed non-solicitation provisions like the one here, and courts continued to recognize that. And I mentioned the Griffin-McLean case, Wellspring, Place for Mom, cases that said exactly that these types of provisions are consistent with the 2019 law. So then the 2024 amendments come along, and I don't think it was coincident that some of the language in the amendments on the provisions track some of the language in the Amazon contract that's being challenged here. But the Washington law is like the federal law and law of every state. So there's a strong presumption that when a legislature changes substantive rights, particularly if they're imposing penalties or disrupting contracts, the law applies prospectively unless the legislature makes it very clear. Directly, this is from the Supreme Court, or from the Washington Supreme Court, directly and unambiguously, clearly makes its intent known that the provision is to apply retroactively to past conduct. The FD processing case also made clear that there's special force to that presumption, where the retroactive application could violate constitutional protections relating to due process and the impairment of contracts. And that's exactly what we have here. These are contracts that, as I said, we believe were lawful when entered in 2019 and through 2024. And they're not seeking compensation. They're seeking hundreds of millions of dollars of punishment based on these lawful contracts, which is a very serious due process problem. And I'll come back to that. So on the retroactivity point, the only case that has looked at this issue and specifically ruled is the Culver case, which said there's no indication. It's a federal Western District of Washington case that we cited from May of 2024. And so there's no indication that the legislature intended retroactive application, and no one has pointed to any. And then the fourth key point here is that plaintiffs themselves recognized, they have to, that this 2024 amendments substantially broadened the coverage and created substantive rights beyond what existed before. It really changed the common law. It changed the 2019 statute substantively to ban these non-solicitation agreements that had been lawful for many years. And plaintiffs in paragraph 8 of their complaint say exactly that this explicitly, they say it broadened it to include an agreement that directly or indirectly prohibits the acceptance or transaction of business with a customer. So there can be no question this was not some technical curative amendment. It's light years away from that. It was a big substantive change that would disrupt hundreds of thousands of contracts. And again, this isn't all just about Amazon. All these other agreements, all these other companies, big companies, small companies, their agreements would be subject to attack in the same way, which would be one of the biggest contract clause violations probably in American history if the law was applied retroactively to disrupt those lawful when entered contracts. And so I think that's plaintiff's main argument in favor of retroactive application. This is some technical curative amendment and remedial, but it's not. It wasn't just a procedural issue. It created an explicit new substantive law restricting these types of agreements that didn't exist before, and then gives plaintiffs, according to them, the ability to seek not only penalties on their own behalf, but hundreds of millions of dollars of penalties for this 100,000 person class, even though there's no evidence about any of those 100,000 people. We haven't had discovery. Plaintiffs, even though they have access to all those people, didn't produce a stitch of evidence that any of those people knew about the provision, were ever affected by it, which the undisputed evidence shows that it was never applied to any of them. So it's a pretty remarkable request to go forward in this case under these circumstances. And I want to make clear, we recognize the purposes of the 2024 amendments. We respect them. Amazon's complying with them. It changed the law and it's changed its policies. So we're not here debating that. It's just the idea of using those amendments retroactively when there's no indication that the legislature intended that to happen in the face of these due process problems. And we cited the U.S. Supreme Court's Landgraf decision, which was a question about Title VII punitive damage provisions in particular being added by Congress. And the Supreme Court said that due process concerns would be very, very big if you interpreted that provision to apply retroactively. And they said it didn't because of this fair notice principle in due process. In 2019 or 2020 or up until 2024, no company would have had fair notice that these sorts of agreements were unlawful, let alone that they could provide a predicate for such huge punishment. And that, I think, flows also from the State Farm and BMW cases we've cited from the U.S. Supreme Court on punitive damages and civil penalties. And then I mentioned this at the outset, the contract clauses of the U.S. and the Wisconsin constitutions apply directly here. The retroactive application of this statute would directly disrupt vested contractual rights. And the Washington Supreme Court, we cited the Lawson case, the Flower case from the Washington Court of Appeals that say, where there's a vested right, retroactively applying a statute or a law to disrupt those contractual rights violates the contract clause and a vested rights doctrine. So those 5 pieces, I think, are just very straightforward. The law is clear, the facts are undisputed, and warrant summary judgment in favor of Amazon. And maybe I'll just address the other points more briefly because they're interrelated. The standing principle, that there must be concrete injury. And here, plaintiffs argue that the mere allegation of a statutory violation is enough to provide the kind of injury in fact that Washington courts require. I mentioned the Benton County case, for example, the Branson case from 2004. There has to be some concrete injury, and the named plaintiffs haven't provided it, evidence of that. It has to be personal. It can't be speculative or abstract. And the Washington courts, Supreme Court has looked to U.S. Supreme Court law on this point. The TransUnion case, which is the most recent case, put it this way: no concrete harm, no standing, even in the context of a statutory violation. And here, as I mentioned probably too many times already, there is no statutory violation. There's no evidence that this provision applied to either of these plaintiffs, was intended to apply, was applied. And it's on the provision itself, Your Honor. I think, as you, I'm sure, are aware, it really was intended. Our position is, and it's clear from the agreement, that it was intended to apply to employees who were customer facing with business customers, like, cloud computing service, sales, marketing for customers using Amazon, not retail customers like you and me, hopefully you, but I don't mean to put you in the middle of it, but to just people who use Amazon to buy products and for other things. It was meant for employees who obtain confidential information, worked with the client customers. That's what it was for. And here, plaintiffs, both of the named plaintiffs admitted they had no confidential information. They had no customer contact that would have even implicated these provisions. And then both of them freely had different jobs. They were not restricted. Ms. Garner worked at Grainger the whole time she worked at Amazon. Everyone knew it. Everyone knew she was applying for a new job. She went to TSA, got a higher paying job. Mr. Burns applied for something like 23 jobs while he was at Amazon. No one ever said a thing. He went on to work at another security company that actually does work for Amazon. There's no one said a peep about that. And so there's no injury, no standing. The most they've come up with is Ms. Garner says she sort of felt fear that this agreement, but there's no evidence that had any concrete effect. In the Washington courts, in all kinds of cases, emotional distress cases, standing cases, have said that sort of speculative conjecture without more is not enough to show any kind of injury that would qualify here. And the Benton County case, I think, is very strong on that speculative injury is not enough. And then, as I said, the class-wide proof, same thing. There's just no evidence that anyone was injured at all. And then the last point on the substance here, Your Honor, the meaning of aggrieved in the non-compete statute. For the Attorney General, there's no aggrievement requirement. The Attorney General can go and file actions because he or she thinks that a company's contracts violate the statute. But the legislature was very careful to say that a private individual, an employee, can only sue if they've been aggrieved by a non-competition covenant. And we believe the plain meaning of aggrieved, the legal meaning, means that your rights have been injured, you've suffered injury. And here, as I've said, there's no evidence of any injury, and constitutional canons support our position as well, avoiding what would be a very, very serious due process problem if $500 million in penalties were awarded where no one had been truly aggrieved or suffered any injury. And then I think the plaintiff's motion for summary judgment should be denied for the same reasons I believe all these points support summary judgment for Amazon. And then the last point I'll make very briefly is if the court determines to deny summary judgment to either party, or to both of us, I guess, then we would respectfully request that we get discovery under Rule 56F of some segment of the absent class members to figure out what the facts are, to see if they were aggrieved, to see if they were injured, to see if they even knew about this provision, and so that Amazon can defend itself if the case goes forward beyond this point.
All right. Thank you, Mr. Boutros.
Thank you.
Mr. Reddy.
Yes, thank you, Your Honor. Good morning. And again, it's Patrick Reddy for the plaintiff and the class. I'd just like to start with the actual facts of this case. What counsel described to you is a complete misconstruence of the facts of this case. These two individuals who are the representative plaintiffs sought out counsel, one after quitting, the other after being terminated. The reason why they sought out counsel is because they each received the same identical letter. The letter says, this is to remind you that you are bound by the terms of this agreement that you signed, even though you no longer work for Amazon. And that was the thing that told them, hey, there's a problem. Everybody who's a member of this class is going to receive that letter when their employment with Amazon terminates. Every one of those individuals believes that for 18 months, they can't work for a competitor. Why? Because the language of the agreement says, accept business from a competitor. The word in there exists because Amazon wanted to control its employees. Point in fact, they wanted to instill fear, they wanted to control, and they wanted to remain competitive. Why use words like accept business from a customer if and say you can't do that for 18 months post-employment if it's meaningless? We're going to make everybody sign this, but we're not going to enforce it. But they're going to believe it's enforceable. These are working class people. These are the lowest wage earners in Washington. The reason why the statute exists is to protect them from this type of control. Now, the 2020 versus the 2024 version of the statute, it doesn't matter. Under either version, accepting business from a customer is non-competition. Counsel said that, well, this is 100 years of precedent. During that 100 years of precedent regarding non-solicit agreements, non-compete agreements were legal. So of course the court said accept is legal because non-competes were legal. So when the 2020 statute came along and invalidated non-competes for low-wage earners, it specifically, without saying it, removed the ability for employers to say you can't accept business from customers. Now, perhaps with confusion because it didn't have the language in there, in 2024, they did do a technical and curative amendment, and that technical and curative amendment was simply to clarify that accepting business is also considered a non-compete. But if you just use, the English language and basic logic, you say, if I accept business from a customer, am I soliciting that person? No, I'm accepting. So if I'm not soliciting them, then what is being done to me with this language? I'm being forced not to compete. That's exactly what that language does. So again, we're here after a year of litigation, plenty of discovery, class certification notice to class members, multiple motions to try to get this case thrown out, multiple attempts to stop class certification, and it's got this far. And I know Your Honor wasn't here for the better part of that, but it's gotten to this point because if you just look at this language, you can tell it's a violation of either statute. Plain on its face. The statute does not require that someone face enforcement of the non-compete to be aggrieved. It does not require that they, the contract, they got a paper cut from the contract and now they're bleeding, right? It doesn't require that. It's the existence of the contract. The law was put into effect and amended so that these people could be protected. Amazon changed the language not after 2024. They changed at the 2024 amendment. They changed the language after they got sued. Plain and simple. They got caught, and they're trying to hide behind technicalities and standing arguments, constitutional arguments that don't apply. Article 3 of the Constitution does not apply to this case. The cases that we cite with regard to standing, McFarland v. Tompkins, West v. Seattle Port Commissioners, questions of standing under Washington law begin with the statute themselves. So the fact that the statute exists, the statute provides for damages of $5,000. The legislature knew it was difficult to prove what counsel admits is difficult to prove in this case, that there was actual harm. And that's because the existence of the contract is harm. They're aggrieved by the existence of the contract. They received letters saying, you're reminded of your obligations under this contract. All Amazon had to do, and that's what I'd also like to focus on, what could they have done that would have prevented all of this from happening? They could have just simply used language that says, you cannot solicit our customers, you cannot solicit our employees, and we wouldn't be here. But they went one step further. If a customer reaches out to you, you can't accept that business. Oh, hi, Mr. Burns, we noticed you're not here anymore. We'd like to, you to do work for us. He would have to say no under this contract. Being reminded of it, seeking counsel to inform them of their rights. And guess what? Yes, they did have rights, and they are enforcing their rights. And they're great representatives because one being terminated and one quitting, both having the same fear. Both of them, neither of them worked together. They didn't know each other. Two different divisions of Amazon, and they had to sign the same exact agreements. So Amazon was well aware of the 2020 statute. They presumably changed this agreement when 2020 came along, and they applied this agreement to their low-wage workers to exert the maximum possible control with being able to claim that it's not a non-compete. And that is simply unacceptable. The court cannot allow Amazon to get away with this for all of these people. If we want to talk about, who does this apply to or how are people harmed, the class notice has told everybody of this lawsuit. When we, send the notice of your award, do you want to accept your award? Did you sign this agreement? Yes or no? People don't have to accept the award if they don't feel like they ever knew about the existence of this agreement. But the fact that two people from two different divisions who are, in fact, customer facing, sign the same exact agreement and both receive the same exact word for word letter reminding them of their obligations under this agreement shows how wide and sweeping this control was. So I think that the reality of the situation as compared to Amazon's position is vastly different. The facts are the facts. Summary judgment must be granted in this case. We cannot put this language in front of a jury and ask them to interpret it under the statute. That's not something we should do.
Can you just assume, for the sake of argument, that that the language of the contract doesn't violate the 2019 statute, that it doesn't meet the definition of non-compete, that it is in fact a non-solicit? Can you address the retroactivity argument then? Because it seems to me, it seems to me that the 2024 amendments broadened the definition. It significantly changed the landscape. It imposed liability that didn't exist prior to the amendments. So can you address that argument about retroactivity?
Yeah, absolutely, Your Honor. So again, the precedent before having to do with non-solicitation, saying that accepting business is part of a non-solicit, and that's okay, that was completely thrown out in the 2020 version of the statute. Because what happened was the legislature invalidated non-competes for low-wage workers. When non-competes existed and non-solicits existed, they coexisted. They were both legal for all employees in Washington, subject to the years of precedent, restrictions on geographic location, duration, all of these things applied, right? When the 2020 statute came along and non-competes were made illegal for low-wage earners, that right there made this agreement illegal. So we don't even have to look to 2024. It isn't a change, it's a clarification. Because again, the logic of it is you can have a non-solicit and a non-compete at the same time prior to 2020. Post-2020, you can only have a non-solicit. If you can only have a non-solicit, then accepting business from a customer is competition. That's non-competitive language. And because that change existed, they wanted to clarify that, right? It already happened. This is not as sweeping as counsel claims. So again, if I'm operating under strict, you cannot accept business from a customer, that's a non-compete under both versions of the statute. Just because it doesn't say accept, that was a clarification that was made to avoid further, companies putting things in there that were still non-competitive, right? If I just say non-compete, accepting business is non-competition. Okay, it's that straightforward. Now, I know that requires a much more in-depth and technical review of this language. We have to look very closely at the words, and we have to get very analytical. And I think that's why the legislature made the change. They didn't want it to be having all these analytical inquiries with long, broad, sweeping language, and how do we interpret this and how do we interpret that, right? They didn't say that a non-solicit agreement has to be limited to 2 sentences. They could have said that, right? That would have been interesting. If that was the case, that would have been a sweeping change, because Amazon could come forward and say, well, this is like 5 sentences or 6 sentences. How are we supposed to know that they were going to change the law in the future and we had to go, that would be a retroactivity that would not be fair to Amazon. But here, where both versions of the statute actually make this contract illegal, that's a technical and curative change. So I think that, and that's very, very important here, because when we're talking about the history and the common law, we can't go back and take cases that were pre-2020 that allowed certain types of non-solicits because they didn't analyze it under the thought process that non-competes were illegal. Now that we know non-competes are illegal, we look at this language and immediately we say, oh yeah, that's obvious, right? You can't accept business. If you can't accept business, then that's anti-competitive. Again, why put that language in there if they didn't want to exert that type of control over their employees? And why are we even here today after a year of litigation if this wasn't the case, right? Because the courts that have looked at this very, very closely, language just like this, there's a complementary case, maybe Amazon, with Judge Vargas, and she recently denied a motion to dismiss for the same reasons. Because here we have language that obviously violates either version of the statute. And if we look to freedom bans, I think that's very, very informative, because freedom bans interpreting the statute said, if you're going to have restrictions on employment, they have to be narrowly tailored, very narrowly tailored. Does language saying that you accept business from a customer, is that narrowly tailored? No, that's broad. Saying that you can't solicit, that's pretty narrow, right? Non-solicits are illegal. Okay, let's do that. But broad sweeping language, such as in this agreement, that has been analyzed again repeatedly over the last year or 2 years and a half by this court and other courts. This should not be here if now all of a sudden this is simply a non-solicit. Why change the language? Well, I guess it's because of 2024. No, it's because you got sued. If people don't enforce this, and the Attorney General on aggrieved, the Attorney General isn't enforcing this. Somebody has to enforce it. And if private citizens come forward, as the statute allows, and decide that they're going to protect their coworkers, other people, then that's okay. That's acceptable. That's the purpose of the law. It's to effectuate change. And counsel also mentioned that there would be sweeping, billions of dollars of lawsuits if this happened. Well, this is the only case that has been filed that is challenging the accept business, right? So if that was the case, then why is there only one lawsuit? Why is Amazon the only one who did this? And why is Amazon the only one who gets off scot-free? That's not fair. So for all of these reasons, we believe summary judgment is appropriate, and we would request that you issue summary judgment in favor of the plaintiffs in the class. Thank you.
Thank you, Mr. Reddy. Mr. Boutros, did you want to respond?
Please, thank you, Your Honor. First, the court asked Mr. Reddy to assume that the agreements were lawful under the 2019 statute and what that would mean in terms of retroactivity. He did not answer that question because he loses if that's true. It's not credible in the least, since their complaint in paragraph 8 says the 2024 amendments broaden the statute to cover more agreements. They admitted that in the agreement. That's number one. Number two, counsel is, I guess, suggesting that the court won't actually look at the statutory language. It's not complicated. The 2019 statute specifically legislature decided to only prohibit non-competition covenants that, quote, prohibit an employee or restrain an employee from engaging in a lawful profession, trade, or business of any kind. That's a non-competition agreement. That's what was barred by the statute. And plaintiffs do not argue that this provision came close to barring them from participating in any profession. On top of that, and again, this, I think, destroys the credibility of plaintiffs' arguments here. The statute specifically said non-solicitation agreements are not defined, part of the definition of a non-competition agreement. And a non-solicitation agreement is one that restricts an employee for a limited time from soliciting and seeking and accepting business from customers of their employer once they leave. That's a non-solicitation agreement. The 2019 statute is all the courts who interpreted it, Griffin McLean, Wellspring, Place for Mom, said that this 2019 statute did not restrict that because it explicitly says that. So Mr. Reddy's banking his entire argument on this notion that the 2019 statute says something completely different than it says, and has no answer for the retroactivity question. If ever there was a situation where a statute should not be applied retroactively, it's where we have hundreds of thousands of contracts that were lawful when they were signed, and that's what we have here. They would be, the contract clause of both constitutions would bar that sort of retroactive application. The strong presumption against retroactivity. We don't even need the Constitution. There's no evidence, counsel pointed to not one whit of evidence that anyone intended this to be retroactive. In their briefing, Your Honor, they pointed to some private citizens and advocates who argued that there should be this new change and it should be retroactive, but that's not evidence. In fact, the FD processing case from the Supreme Court of Washington said that a single legislature's statements aren't enough. And so there's just no evidence, and all indications are this was not meant to be retroactive. Counsel also is wrong that the company only started changing its processes, its contract, when the lawsuit was filed. Actually, Amazon started in June to change the language. June of 2024, the lawsuit was filed, I think, in October. So that's just factually wrong. And I don't think anyone quit or anyone was terminated. Either named plaintiff was terminated. They were both looking for new jobs, and no one restricted them. They got those jobs. Also, Your Honor, I think when you're representing 100,000 people, as Mr. Reddy is, to declare that everyone was afraid that this restriction applied to them, everyone in the class, without providing any evidence. There's no evidence that anyone thought this, of the hourly employees, the employees below the threshold, thought this provision applied to them. There's not one stitch of evidence. And the 30B6 evidence is that from our witness that it was never applied to this group of employees because they were not customer facing, because the company doesn't even know where they go in their next job, and the company doesn't ask. So I'm not the one that's coming up with facts that aren't accurate. The record is very clear. I know the courts reviewed it on these issues. But the clause does apply, it did apply, and does apply to some higher paid employees who deal with customers and get confidential information. So it's not like it's a nullity. And Your Honor, if you look at the agreement, it has other provisions that clearly don't apply to Mr. Burns or Ms. Garner. Like, if you invent something or you come up with a patent, it belongs to the company. Well, they weren't restricted by that because it clearly didn't apply to them. So I think on all those points, I come back to the retroactivity point. These provisions were lawful. No one sued about them until 2024. So you thought Mr. Reddy, who seems pretty aggressive, if he thought these agreements were unlawful in 2021 or 2022 or 2023, he would have been in court bringing the same kind of case. But of course they didn't, because he knew, all the lawyers, all the judges in Washington knew that the statute explicitly says non-solicits were lawful and that the non-competes were narrowly prescribed in a way that just says you can no longer go perform your profession anywhere for a period of time. And that's not what we have here. And then on the reminder letters, Your Honor, I would just point to the Culver case from the Ninth Circuit that said and it affirmed a district court decision on this very issue, saying the reminder letters didn't say anything about enforcing these provisions. And again, it just said, remember, you have this agreement, some provisions may apply to you, and if, they still apply, and just reminded them to adhere to their obligations, which, as I mentioned, the non-solicit clearly didn't apply to these employees, and no one ever suggested that it did. So for all those reasons and the reasons I gave before, Your Honor, we think this is a summary judgment case. The company's trying to do the right thing. We respect what the legislature did. These agreements were lawful. No one ever suggested they weren't until 2024. And that statute significantly broadened this provision in a way that deeply affects substantive rights and would produce massive punishments in this one case of $500 million, which would violate due process in the contracts clause.
All right, thank you. Mr. Reddy, they're cross motions. I just wanted to make sure, I wanted to give you an opportunity. If you have a rebuttal of any sort, I wanted to give you a chance to do that. I've got a few minutes.
Thank you, Your Honor.
Yep.
Thank you. Just real briefly on the issue of, why nobody sued Amazon sooner. Well, we sued Amazon as soon as two clients came to us. Two clients who thought that they were facing dire harm enough to reach out to attorneys who, attorneys aren't free, right? Why would they call us if they didn't think there was a problem? That's why. And sometimes it does take time for people to notice things, words that are buried into a very aggressive, if you want to talk aggressive, a very aggressive contract. The reminder letters don't read softly. They read very harshly. And that's what triggered this. But getting back to retroactivity, we pointed out in our briefing that the legislative history clearly confirms that the 2024 amendment was put in place to clarify the law, not change the law. The legislature expressly adopted the 2024 amendment because, quote, the courts have misconstrued non-acceptance of business clauses as non-solicitation covenants. And that's from the legislative history. And the stakeholders who helped draft the amendment also testified that the proposed modifications to the definition of non-competition covenant is intended to clarify one principle that the courts have struggled with. That's a quote. So that's why they changed, that's why they put forth the amendment. They didn't do it because they wanted to change the substantive rights of individuals. They did it because courts were confusing exactly what we're looking at today. And I can see how it can be confusing, because when counsel says what he says, it creates a lot of confusion. But if you take a step back and you simply look at this contract and what these people felt about the contract enough to go seek legal counsel, this is an invalid, illegal, non-competition covenant, and one of the largest companies in the world deserves to pay for the damages that it caused. So for those reasons, we'd ask that the court grant summary judgment in plaintiff's favor. Thank you.
All right, thank you. All right. So I think this court has. I'm really, frankly, skeptical that that plaintiffs have standing in this case, that they have demonstrated they are aggrieved. But I agree with the defendants that this court doesn't need to rule on those issues, because in this court's mind, it is clear that the agreements at issue here did not violate the statute that was in effect at the time that they were signed, and the amendments to the statute are not retroactive. The court is going to grant defendants' motion for summary judgment on that ground alone, that the challenged non-solicit agreements were not prohibited by the statute at the time that they were signed. The court is persuaded that the customer non-solicit here, in this case, it's not a non-competition covenant under the applicable version of the statute that was in effect when they were signed. That version of the statute limited the definition of non-competition covenant to contracts by which an employee is prohibited or restrained from engaging in a lawful profession, trade, or business of any kind. that version of the statute expressly excluded non-solicitation agreements from the definition of prohibited non-competition covenants. It also confirmed that it did not intend to modify the common law on that issue. The statute was then, of course, amended in 2024. The court also finds that plaintiffs have not overcome the presumption against retroactivity. And that's where the court begins, is that the presumption that generally statutory amendments are presumed to operate prospectively. That presumption against retroactivity is overcome where the legislature expressly provides for retroactive application, or relevant to this case, where the enactment is curative. The 2024 amendments do not expressly state that they apply retroactively. And in fact, the language of the statute, the 2020 statute, states that the law applies prospectively. The 2024 amendments didn't change that. There was nothing about the language of the amendments that changed that. The legislature certainly could have done that if that's what they intended to do. They did not include that language. There is, of course, also an exception for amendments that are curative. But an amendment is curative if it clarifies or if it technically corrects an ambiguous statute. But here, the amendments, this court does not find that the amendments are curative. They significantly broadened the statute's scope, and plaintiff acknowledges that in their complaint. It significantly expanded the definition of a non-competition covenant, and in doing so significantly affected substantive rights. So the court does not find that that the amendments are retroactive. The agreements here were not prohibited by the statute that was in effect at the time that they were signed. The court is going to grant defendant's summary judgment motion on those grounds. Mr. Boutrous, I think I have a proposed order from you. I think I saw that in the materials.
Yes, Your Honor.
All right. So I will get that order signed. I will get that out today. I want to thank you all for a really interesting briefing and argument today. Any questions?
No, thank you very much, Your Honor.
All right. Thank you both. That concludes this matter.
Thank you.